You're listening to the Valley Current.
Hey, Bob, thanks for coming on. The topic for everyone listening, we're here on the eve of July 4th, which is a big holiday in the U.S. You're living and working in a small town in the country of Laos now, doing some great charitable work. We've talked about that before. And we have had a pretty good discussion about some of these Supreme Court cases before the decisions, where we just simply outlined some of the arguments that were happening. And we get to the end of the session of the October term that started October 2023. They kind of work, I guess, 9 months out of the year, and then they take July, August, and September off. I guess they're a little bit sort of like tenured professors in a way that they do that. That's great. And I think they would say they do a lot of work during that 9-month period. They probably also arguably work during the 3 months they take off, although now there's a lot of scrutiny about who's paying for what in terms of who travels where. And I'm sure there'll be more of these stories. But generally, we're covering the end of the U.S. Supreme Court's term, which just ended June 30th, and a flurry of decisions came out, a few of which we had touched on in different podcasts during the year, starting with the October term, October of last year. So 9 months have passed, and we thought we would do kind of a roundup on at least 3 of the cases that certainly have hit the newspapers, at least 1 or 2 of which we previously commented on. And which one do you want to do first, Bob? 303 Creative?
Well, you suggested 303 Creative, and I'm ready to do that. That's fine with me.
Yeah, I think that makes sense.
Then comes the fair admission.
Yeah, I think that makes sense, because I think we took kind of an interesting combination of views in the previous podcast. And just to refresh the audience, 303 Creative is about a single person LLC. An LLC, for those who don't know, is a limited liability company. It's a separate entity. She was in the business of doing websites, I guess, but she wanted to extend the business to doing wedding-based websites. And she hadn't actually started to do that business yet. So there was kind of a standing issue in the case, which to some degree.
It was not. I mean, I hate to start with a contradiction, but both sides stipulated to the facts about that the Supreme Court analyzed. So neither was in a position to say the other guy has no standing.
Right. Cases and controversies are what the Supreme Court is supposed to decide. That means no advisory opinions. That typically means that you have to have standing. And I don't think necessarily that one can stipulate the standing, but you could argue maybe one can, because if that's true, it really means hypothetical cases, not real cases and controversies, could be effectively stipulated to. They did that in this case. That's subject to a lot of criticism, because recently it came out after the decision was issued that the guy who supposedly was the man who wanted the cake done was actually not gay and never asked.
Not a cake. It was not a cake, but a wedding website. But
I
want to start by talking about the prehistory of this case, which did start, because I really think it's critical. And it did start with a case in which a baker was asked to make a cake to celebrate a gay wedding and refused, and was brought up before the Colorado Anti-Discrimination Commission, and they pounded on him, and it went to the Supreme Court in that posture. Now, in that posture, some of the members of the Colorado Anti-Discrimination Commission gave statements showing that they had prejudged the case, or at least so the plaintiff argued.
Mm-hmm.
And Justice Kennedy, writing for the majority, said, that's true. They fatally compromised themselves by coming out with this anti-evangelical rhetoric And so we're dismissing on that basis. But Kennedy continued, whenever the outcome of some future controversy involving suspects similar to these, we will then look at the substance. Okay? Now, there's a group called the Alliance Defending Freedom, which is a Christian supporting litigation engine, basically, that goes around trying to vindicate people like the baker. And so they heard this invitation and basically concocted this case. Okay?
Right.
They found Lori Smith, who does websites. Lori now says she wants to do websites celebrating marriages that comport with Christian theology. In other words, one man, one woman. She doesn't want to do gay websites, but she's afraid the Colorado Commission will land on her if she goes into that line of business. And so she wants a pre-enforcement decision. And it does sound a bit concocted, doesn't it?
But it's very rare that you have the degree of cooperation that occurred between a state.
Yeah, but you had it. And in the course of getting that cooperation, Lori Smith, or rather the ADF, and Colorado entered into a series of stipulations, which I thought at the time would bury Colorado. And it turns out I was right. Okay? They stipulated that this is pure expression, that every website is original and customized, and that the website is there to communicate ideas, namely what weddings are all about. And once they finished stipulating to that, holy crap. I mean, really, this became a pure free expression case, not an exercise of religion case. The question is why Colorado stipulated to these facts. I know why the plaintiff did, because she wants to put it in the guise of, and by the way, the last time we did this, you played a video from that Alliance Defending Freedom had also concocted for Lori, showing her with different colored pencils and making storyboards and yada yada.
Right.
Okay. You and by the way, Sotomayor and Kagan tried to argue that the free expression is really de minimis. You do the website, it tells you where the wedding is, it tells you who the people are, it tells you where the hotels are if you're coming from out of town, and basically that could be anybody. It's really quite generic. There was one page of the website in which the couple talk about how they met, but that aside, it's pretty generic.
Right.
And so Sotomayor, in her dissent, kept saying, if this impacts free speech, it's in a completely incidental way to enforcing equal access to a public accommodation. Well, Sotomayor can argue that until she's blue in the face, but they stipulated to the contrary. So what good does it do her?
Right. I mean, I think the point that I'm making about stipulations in federal courts, when you're dealing with the question of standing, a judge can still probe that. For example, people can't stipulate diversity jurisdiction exists when the facts are pretty clear that, or the facts may be even questionable, that, hey, you guys are both citizens of the state of California. No, we just stipulated that that's not so for this case. Judges can pierce through that. They're supposed to jealously guard their jurisdiction. Standing is another way to jealously or to carefully make sure federal courts remain courts of limited jurisdiction. In this case, I just wanted to point out, because I didn't think we did it the first time around, the entity is an LLC. It's a separate entity. The LLC is not Lori, the individual. Now, probably it's a single owner entity, although I bet they probably built a lot of stuff into the operating agreement for the entity that said that she had to get input or accept votes from people that are funding this litigation, I would imagine, because obviously they were investing a fair amount of money. That's my hypothesis here. and they did this as an LLC, it might be a stronger First Amendment case in my mind if it was her individually. There's no real commentary about that in the case, but in theory, I think one could argue.
The same issue came up. Yeah, the same issue came up in the loan forgiveness case, and there it was argued by Kagan. So as for this case, we had this like standing invitation from Kennedy to bring the case again.
Right.
So they brought the case again. Yes.
Yeah, I'm just saying, I think at the end of the day, it sort of tends to show that the court has a lot of discretion. I guess all federal courts have a lot of discretion to decide whether they want to extend their jurisdiction, or if
I agree with that. Yeah.
If they decide that, no, we really don't want to do it. We don't want to do it yet. It's not the right vehicle. They have checklists of how they look at these things, because they get what, 5,000 to 10,000 petitions a year, and maybe 1% is 50 to 100 cases maybe get fully briefed, and out of that, some of them end up with some type of summary sort of remand, or improvidently granted a bunch of non-decisions, and then a bunch of them end up with written decisions. I don't know what the exact stats are. One could get that probably off of SCOTUS.gov, SCOTUS.gov. But sure, this case was concocted with the cooperation of the state. The state stipulated, the stipulations were pretty dramatic. And at the end of the day, I think they wanted to imagine it was possible to get a pretty broad protective ruling for the state of Colorado and all other states that have these laws, because there's more than just the state of Colorado that has these laws. And they didn't get it. They got the opposite. They got effectively a very broad First Amendment decision that more or less says one can assert a First Amendment right to choose not to accept a particular type of project. I suppose you could extend that to say, including from a particular type of customer, and that's where things kind of get fuzzy.
It occurred to me, and it also occurred to Buddha Gang, when you sent me that article, that what if this were an interracial couple, not a gay couple? Okay, it would be identical on the facts.
Right.
Jack Phillips, the baker, or Laurie Smith, the website designer, could say, I'm sorry, but the Bible doesn't believe in miscegenation, to use that old word, and so I don't want to make the cake. It's legally indistinguishable, but the court would have had a much more difficult time writing that opinion, don't you think?
Yeah, I think it's going to come, though. I mean, look, I think there's always a lineup of cases, as you discussed, where particular decision gives rise to dicta, and the dicta more or less sets out a roadmap for how a case might be more within the line of what the justices will take. This case was constructed to get this ruling, and it got the ruling that it expected to get. I mean, I'm not going to say it was coin operated. I'm sure they spent a lot of time kind of building the arguments and doing everything it took to get to where they got this ruling. But at the end of the day, we have now a First Amendment ruling that can be asserted in a larger number of contexts, and it will be asserted in a large number of contexts. Yes. And there will be a lot more federal litigation where the First Amendment is asserted as a defense to various state laws that are trying to, I'll just call it, flatten the manner in which businesses, I mean, these are laws that are about businesses accommodating and being neutral about in a non-discriminatory way to the customers and projects they take. And 303 Creative is probably going to give rise to a much larger number of cases as various laws. I think even in the area of renting real estate, you and I had a little offline discussion where you disagreed with that, but I think we're going to see landlords make a suggestion that their particular projects are kosher, and anyone that doesn't have a kosher kitchen is ruining the whole building. And this is a religious belief, and most people in the building are Jewish, and they want to keep kosher, and that has all sorts of
I don't know if Jewish law says that once a stove has been used to cook pork, you can never use a stove again. I don't know if that's the case or not, but if it does, then I guess there's some kind of argument. I mean, you're basically trashing the building. But in general, the question that's raised, and I agree with you, the question that's raised is, where are the outer limits of this? When it's pure free expression, and I reassert, this is a free expression case, thanks to the stipulations, and thanks to the question that the Supreme Court framed. They framed it as free expression. Whether Jack the Baker would be covered or not is still an open question. The Professor Volokh at UCLA, who specializes in First Amendment cases, thinks that the cake guy is not covered, but Laurie Smith is covered. So this remains to be seen.
The cake guy is not covered because he's not really creating an expression with the cake, but Laurie's covered because she's doing a website with some colored pencils.
That's what he says. What do you think?
I mean, I like him and I know him, and I've given some money to him as kind of a generous act, because he's got this little First Amendment clinic where he's teaching my alma mater, UCLA Law School, various students on how to write briefs, and basically all of them are amicus briefs that he's doing in First Amendment cases around the nation. I think he needs to be applauded for that. And I think his views are always pretty important, and he's been cited a few times by the Supreme Court. I don't know. I mean, part of the reason I can't say I totally agree with him is because I think this decision is very malleable around what actually is the degree of expression that has to be done to kind of invoke the First Amendment. And as I said, right in the first podcast we did, where we were sort of predicting outcomes, they said, ChatGPT and various AI programs are automating the creation of a lot of this stuff, and most people are welcoming that automation. It lowers the price. Sometimes it generates even more creative thought, often by the automation itself. So if you have a piece of software that does all this stuff, and all you do is make sure that the typography is right, are you really more than a typist at that point if the software itself is doing all the work? And are you really within the scope of triggering the First Amendment, or are you more like the guy doing the cake, where you're mixing a bunch of stuff together and presumably creating an object that's not a form?
I agree with you. The amount of creativity that goes into taking a website and accommodating a gay couple is really rather small. Yeah, and you could say on the facts that it's de minimis, but they can't say that because they stipulated to the contrary.
Right.
Okay.
Right.
So they screwed themselves, basically. As for whether the cake guy is covered, I think there's probably more expression in decorating a cake, right, than this de minimis thing. But then the florist comes in and says, well, I very thoughtfully picked the flowers, blue for the boy, pink for the girl. Become what's the word I'm looking for? Pretext. I mean, just nonsense. Come off it.
Well, I think that's actually a good segue into the second case, because a lot of people think that the affirmative action case has a bit of pretext in it, where by the very end of the ruling, even though they're now saying that giving special weight to minorities in admissions to college is in fact illegal under the Equal Protection Clause of the 14th Amendment, there's, at the end of the opinion, there's basically a suggestion that colleges can do something that sounds very pretextual, which is just look at the essay, and if the essay talks about challenges that exist because of minority status, that's okay. I mean, I think a lot of people reading
Totally
that
agree
think
with
it's
you.
a joke that the Supreme Court is making a roadmap for how universities can more or less keep the
It's
status quo.
game the system, exactly.
I
But
mean,
but frankly, the whole thing from start to finish has been taken over by game playing. But before we get into that, let me just sum up on 303 creative, and then you can take the laboring oar on fair admissions.
okay,
One thing that struck me is that uh, Gorsuch, who's a rather dogmatic guy, and Sotomayor, who's rather dogmatic too, were talking past each other for I mean, they just didn't grapple with each other's issues. They just dismissed each other's issues. And I want to pick up on this at the end of our session. What's going on with the Supreme Court? I
right.
mean, they're really not dialogue at all anymore. And this problem is restated in the loan forgiveness case as well. So I just want to highlight that now because we'll be going back to it later, I hope.
Right, we will. And I do think it's a big point because you would think when a tenured justice, and they are tenured right up to death, and there's big issues now about whether that's such a good rule because we have a few federal circuit court judges who are claiming that other federal court, at least one other federal court circuit judge who's in her 90s, is really unable to carry out her job. And, it's pretty much a discretionary decision of the justice when he or she decides to retire. And as we saw with RGB, Ruth Bader Ginsburg, she decided not to retire. And that caused, in many ways, the domino effect of the Obama administration.
Well, what it caused was Amy Barrett being on the court, where Biden would have been elected and there would have been a different outcome. Yeah.
Right. So the point that this attaches to is the court is now composed in a way that's very different than the court that it has historically existed. It's far more conservative. It's far more open, certainly since the Dobbs decision on abortion, to reversing quote unquote settled precedent, often precedent that's been settled for decades, which, there are examples where that happens, but they're rare. And it's more willing to do what might be called a non-scholarly approach, I guess is the way I would say it. But we'll get to that at the end. Let's turn
Yeah,
to,
I think we should.
yeah,
I mean, you just emphasized the substance that they're more conservative, but there's also the process point that they are not engaging with each other anymore. They're just standing on soapboxes and throwing mud balls at each other.
Right. So the Supreme Court decided a case that's called the Students for Fair Admissions, Inc. versus the President and Fellows of Harvard College. Harvard and many other universities have too many applicants for the number of seats. That's been common for a very long period of time. There's some interesting statistics in the case about just how many people apply. There was also the University of North Carolina. There were sort of like two different cases here that were joined together to deal with this question of, is the law that has historically existed that has allowed these universities to give more weight based on race?
Stay tuned for part 2 of this episode of the Valley Current.